the guns.
Justice Oscar Angote is the presiding judge of the Environment and Land Court. This is a division of the High Court, is it? Or is it? It's a superior court.
It's a superior court. It's an independent,
superior court.
It's one of the 5 superior courts.
Very good. Justice, welcome to Kenya's biggest conversation. Welcome to Justice Thursdays.
Thank you very much for having me here. And thank you for the listeners and the viewers. Let me say hi to all of them and to my colleagues who are preparing to go to court and serve the people of Kenya. Thank you very much.
Do you promise that everything you say here shall be the truth and nothing but the truth?
It shall be the truth. It shall be the truth.
Judge, Environment and Land Court is 10 years old now. So tell us about the thinking behind the establishment of this as a superior court. It's established by a piece of legislation. What is the thinking behind this? And tell us about the last 10 years.
Let me start with the first issue, the thing behind the establishment of the court. At independence, all the matters relating to land and environment were being dealt by the magistrates and the High Court, depending with the legislation under which the pieces of land were registered. And those pieces of legislation are the ones which were guiding the parties in which particular court they're supposed to file their cases. So we had the High Court and the magistrates dealing with all land disputes, amongst other disputes. Now, this did not actually work well because, remember, at independence, we were having so much in terms of adjudication of land, titling, and also we had the colonial titles together with the grants which the government was allocating to people. And therefore, there were so many disputes around that particular area. And the issue of the delays and the many disputes that arose led to the creation of a specialized court known as the Land Disputes Tribunal. It was actually a tribunal which was formed at every divisional level so that Kenyans can go to those particular tribunals and have their disputes heard expeditiously. And these tribunals were actually headed by elders within divisions. And it was hoped that the disputes are going to be settled quickly. This tribunal had very specific mandate. It was only supposed to deal with boundary disputes and, of course, issues of trespass. But that did not also solve the issue of delays in terms of land disputes. And when we had the Ndungu Commission in the year 2003, the Commission recommended that we need to have a specialized land titles tribunal because what happened is that the tribunal was actually not doing what it was supposed to do. It was even overstepping its mandate in terms of dealing with the titles, which the law prohibited it from doing. So the Ndungu Commission recommended for the establishment of land disputes a land titles tribunal. But when Kenyans had this conversation during the constitution-making process, they say, let's just have a court which will deal with environment and land court. And this particular court should have the status of the High Court so that it doesn't feel that it is a much lesser court in terms of encouraging Kenyans to go before it and deal with those specialized issues quickly. And that was why in the 2010 Constitution, one of the 5 superior courts was the Environment and Land Court, which is a court of the same status with the High Court. So the thinking, just to answer your question, the thing behind the court was that this is a court which should be formed so that it can expeditiously deal with the land disputes in a very specialized and systematic matter. It was supposed to be a court with what we call competent, comprehensive, and centralized jurisdiction, so that it was supposed to be a one-stop shop for all land disputes.
All matters of land.
And it was expected, and we still have those expectations, that the court was supposed to deal with all the land problems that Kenyans have been facing. So that was the reasoning.
Does it mean that for matters of environment and land, you don't have to start at the magistracy? You come straight to this court?
Now, that was the initial conception. When you read Article 162 2b, the court was supposed to deal with disputes relating to environment and land court. However, it was realized that magistrates are found in each and every corner of the country. In 2016, the law was amended because the court could not just deal with all manner of disputes. You know, you are talking about bundle disputes and all these other small disputes.
Yeah.
So the law was amended in 2016. The Magistrates Court Act and the Environment Land Court Act was amended, giving jurisdiction to magistrates to deal with land disputes of a particular value. So magistrates can actually deal with land matters whose value does not exceed 20 million. Any dispute whose value exceeds 20 million has to be heard by the Environment and Land Court as the first port of call. So that position changed in 2016. But between 2012, when the court was first operationalized, to 2016, the court was dealing with all matters, and it was impossible. Because, as I will tell you, we started over with only 15 judges in 2012. And right now we are 51 judges. So you can imagine how 51 judges were supposed to deal with all land disputes, and that's why the laws are amended. So actually the magistrates now have jurisdiction to deal with land disputes and environmental disputes whose value is less than 20 million Kenya shillings.
Okay.
So what did you do with the cases that were of value below 20 million after 2017? Did you now push them down to magistrates?
We did not, because we realized that if we did that, we are going to even create a chaotic situation, because these are Kenyans who have been waiting. The cases have been filed in our court, and then you all of a sudden wake up and tell them, go back to the magistrate. So we had practice directions to the effect that cases which had already been filed can continue in the Environment and Land Court. However, new cases should be able to be filed in the lower court, except where the parties agreed that because of the distance, take us back to the magistrate's court. So where there was that consent, we will transfer most of those matters to the lower court. But the policy that the court took was that any matter which had been filed before 2016 should actually continue being heard in the Environment and Land Court, so as to save the Kenyans this back and forth situation that they found themselves in at that particular point in time.
So which kind of cases then? I mean, you said any land cases that exceed a certain amount in terms of money. So what kind of cases then? What's the stuff of the cases that comes to court? Individuals disputing over the ownership? Are we talking about entities taking over land in succession? Are we talking about inheritance? What scope then comes
Yes,
to
the jurisdiction of the court is very limited to deal with what we call land use, land occupation, and titles. Now, it does not mean that any dispute which touches on land will come to the Environment and Land Court. For example, succession matters don't come to the Land Court, they go to the High Court.
Okay.
Because that is not a dispute on land use, occupation, and title. That's a dispute relating to distribution of property among the family members. So we only deal with what we call land use, titling, and occupation. The other example which I can give you is in relation to commercial transactions. When you're talking about charges, when people charge their property for purposes of getting loans, that one is a commercial transaction. It does not come to the Environment and Land Court. It goes to the commercial division of the High Court.
Okay.
So our jurisdiction is very specific, but more or less it deals with almost all land disputes, except probably those two that I've mentioned, succession and commercial transactions.
So what is land use? I mean, it sounds obvious, but it could be that we are thinking something totally different. What is land use, really?
Land use, just if I can simplify it, it just means that there is a tenure system whereby you are given a piece of land for a specific purpose, either agricultural, either for commercial purposes, or you are a tenant. So that is use.
Yes.
So when you are contesting, let's say, a tenancy issue, you are talking about a use of land.
Okay.
Or agriculture, you are saying, I'm the one who should be farming this piece of land. That is use. or you are saying this building is supposed to be used for a studio, so that is land use.
Okay.
So that's why we are talking about, is there a dispute about the use of that land?
Yeah.
So it comes to our court. Then the second aspect is occupation. Who is in occupation of that land? So that's a dispute which will come to our court. Then the last and the most important, and probably the one which is litigated upon mostly, is titles. Who has a proper title?
Who has the genuine
Who
title?
has a genuine title? You have 10 titles. I'm the one to decide who has a genuine title.
So the perennial and everlasting issue of squatters in this country then falls squarely in your court.
It does, because that's occupation and titling.
Right. So then how then has this been? So when you say, to me, it seems as though it traverses those three things of use, occupation, and titles, because it's a big issue. You have communities who have been deemed to be squatters, but have lived easily 50 years in a particular place, and then one day somebody comes along and says, hold on a minute, we actually have the title to this land, in as much as you've been living there. So, I mean, it seems that it's something that then needs to be dealt with delicately, but then who then brings such cases to court? And when you talk about land use where squatters use this land, do they really then have rights when the owners come to court to claim back their land? Do squatters actually have rights that can be disputed in court?
They do have rights in certain instances, and when such an issue comes before a judge, you look at the circumstances, you look at the facts, because the law will always guide you on how to apply the facts which have been placed before you. So squatters do have rights, and those rights have to be looked as against the rights of the title owners.
Okay.
One of the rights which the squatters have is the right of if you, a squatter has been on the land for more than 12 years, and as a title holder you've not done anything, the law actually allows that squatter to come to court and say that I have been on this land for 12 years. The owner has not done anything within those 12 years, and therefore I'm entitled to this particular title. And the law allows the court to make that particular declaration. So squatters do have rights. And we look at the circumstances, we look at the evidence, we look at the facts. Is this a professional squatter who is just moving in and out to get a title, or is this a genuine squatter? So all those facts are actually applied by the judge, and then you look at what does the law say in terms of the rights of a squatter. So they do have rights in certain instances, not always.
Who's a genuine squatter?
A genuine squatter is somebody who has been on a piece of land for a very long period of time, and you need to look at the circumstances under which he came on that land. And there are so many circumstances that can make somebody actually to squat on another person's land. And the most often example that I can give is if you sell a piece of land to person B, and you transfer that land to that person B. And probably when you are selling that land, there was somebody who was already living on this particular piece of land. And this person B does not do anything to enforce his rights of evicting the person who was on that land. Either you invited that person on that land, but when you sold it, the person who bought the land did not evict
Inherited the person in the land.
Exactly.
And allowed them to
continue living on that land. The law says you have slept on your rights. You should have done something within that particular period. And the other example that I can give is where you have people coming on a piece of land, especially where we have absentee landlords. We have landlords who have land and they disappeared many years ago. And you are, hey, I can see a piece of land here, and you put a small structure there and you continue living there. And this absentee landlord does not come to reclaim his land for 12 years. The law says if he comes after 12 years, too bad for him. That is
Okay.
that's the law. That's the law, and you sleep on your rights. You don't recover your land. There's
Shamba
nothing you can.
nakwenda.
Yeah, imeenda kabisa.
So then there are very many people who are squatters, then who already have been there for more than 12 years. It sounds like they have automatic right to that piece of land.
Yes, they do have that right, but that right has to be sanctioned by the court.
Okay.
That's why they have to come to court and say we've been on this land for this particular period of time. The owner of the land has not done anything for the past 12 years. And then we look at the facts, because saying is one thing and proving that we've been on that land for that period is another thing. So we have to weigh this particular assertion.
Your code deals with environment.
Yes.
What does the court consider to be under your purview? What qualifies to be environment?
In environment, when you look at the definition of environment, it's so wide. Environment is almost everything, because even land itself is environment. But when it comes to the issues that come to our court on a daily basis, we are talking about when you are putting land into some kind of use, which factors have you considered? Which environmental factors have you considered for you to put that piece of land into use? And we have laws governing how land use is supposed to be implemented for purposes of mitigating any environmental degradation. But just to answer your question, we are talking about environment. Talking about the issues of air, how we regulating the cleanness of our air, about water, about the issue to do with waste management and disposal. But more importantly, and the case that we deal with on a daily basis is this land use. Are you using it in a sustainable manner as required by the law? Have you complied with all the requirements in terms of taking measures to mitigate any environmental degradation that may arise from that particular land use? However, we still have cases where we deal purely with environmental issues. For example, the issue to do with the river pollution. People come to court and say there's a particular industry here which is polluting a river, or there's this waste disposal which is not being done in accordance with the law, and at the end of the day, it's affecting the soil or the air or the water. So environment, as it were, is very wide, and we deal with those issues as they arise.
So is that why, for instance, if you were to put up a structure in a city such as this one, you would need some environmental approval before you can do so? Meaning an understanding that structure that you're going to put up complies with laws and regulations that are demanded of such a structure in such a place.
It's actually a requirement of the law that when you're putting up any kind of a structure, you must do what we call the environmental impact assessment. So that in that report, and we have experts who are supposed to do that, in that report you are saying these are the impacts that we expect with putting up this kind of a structure, and these are we are going to mitigate those particular impacts. And it's only on the basis of that report that the National Environmental Management Authority, NEMA, will give you a license. You must have a license. And NEMA will rely on that report to say that this structure will have these particular effects on the environment, but these are the measures that we are putting in place. If it's sewerage, you have to show how that sewerage system is going to operate. If it is air pollution, because construction, we have all manner of effluent and debris and all that. You must show how you are going to take care of that. So that's why I was saying when it comes to land use, you must be able to show NEMA that you've put in place measures to protect the environment. In development has to go hand in hand, and it's a constitutional requirement with the protection of the environment.
Thank you. That is clear. There's clarity. And one can definitely demonstrate and show that they will comply. Where my problem, the problem I have in my head comes in is, now, thereafter, the structure is put up. Does an organization, well, I shouldn't ask you this because you don't work for NEMA, but is there sufficient wherewithal to ensure that what was on paper is what actually then takes place after. Because complying with the rule so that you can put up the structure, yes, that is there. Why am I asking this? Because I get the impression that it's because of non-compliance that such cases end up in your court.
True. Very true. And there are many. Because you find that most of the time when developers get licenses, they actually don't comply, or they comply partially. And as a citizen, if you look at the law nowadays, anybody can move to court and say that this person is not complying with the conditions in the license, and in the process is polluting the environment. So that happens oftenly. And now is a court to look at whether indeed those conditions have been complied with and not. And the court can actually stop any construction which is being undertaken without complying with the conditions in the license. And that's where now the environmental issue comes in. Because when you are talking about compliance, you are talking about, as you develop, are you also looking at the requirements,
The
in
conditions
the
of your license.
Exactly.
All very interesting, Judge. Let's take a break and then we'll continue the conversation shortly. Justice Oscar Angote, presiding judge of the Environment and Land Court. He is here today with us, Justice Thursday, to talk about the court celebrating 10 years since it was first established 10 years ago, 2012. This was in November, so you'll be celebrating your 10 years in November.
In November, exactly.
We'll be talking about that and how you want to commemorate. Kuna keki, kuna fireworks,
Zote zipo.
kuna shamba, utapeana kila mtu kaplot, eighth. You know, and all those coming up. You know, this one is not really a dispute that should come before you, but now that you're here and you're a judge, let me tell you about this man,
Yes.
CT. Him and I, as my big brother, we do business together. And there are things that we do together. So we have a land that we own together. So what happened, Judge, is CT came to me and told me, Eric, this beautiful piece of land is going for 6 million shillings. Very nice. Told me where it is. Told me who the neighbors are. You know the way you said, on this other side, kuna judge so and so. This other side ni general so and so.
To entice you.
Na kuna bypass
Kuna maji.
kuna maji pale. Beautiful. I said, let's go ahead and buy. I trust the man. I always trust him. I gave him the money. My share, 50%, 3 million shillings. He introduced me to the person who's selling the land, a man called Joseph. And we signed and shook hands. Turns out later, Judge, this man was the owner of the land all along. Joseph was just a proxy. Now, is that a dispute that we bring to you? Guy had
Now
bought
listen,
land.
listen to it.
Justice.
Yes.
Was the land not there?
It was there.
Did it have an owner?
It did.
Yes.
Yeah.
After all, there was no
After all.
air.
Where is the problem?
Was there a willing buyer?
They are willing buy. Was there consideration?
Were the neighbors as stated? Yes. Was there a river? Yes.
City, you sold me your own land, and you
And he said that you were also bringing 50%.
he bought the land for 1 million shillings. I gave 3 million
Excuse
shillings
me.
for 50% of that land.
Excuse me. I already owned the land. I gave him a deal. Ask him what the value of that land is now.
This is the Situation Room, the only way to start your day.
Eric Latif Ndu Oko and CT Muga with Justice Oscar Angote, presiding judge of the Environment and Land Court, celebrating 10 years of this court, the gains, the challenges, the lessons on to the next 10 years. And Judge, maybe we just start from that. Can you just mention some of the key gains or some of the landmark decisions that have come out of this court that have then impacted the community?
Thank you very much. This court has been there for the last 10 years, and it has done so much in terms of resolving the ever-evolving land disputes in this country. And the judges have really worked around the clock to resolve those disputes. And the record of the court shows that actually it's resolving so many disputes. Now, on the issue of landmark cases, I don't want to specifically talk about particular cases, but the court has dealt generally, and in terms of issues which affect people, We have dealt mostly with the environmental issues that affect the Nairobians, if I can just talk about Nairobi, because this is where we've had so many challenges when it comes to environmental disputes. And one of the disputes, we all know, we had the dump site in Dandora. The court was very firm about that, and it said that the people of Dandora and the environments need to be protected, and that dump site need to be moved somewhere else where we will not have people mingling together with all manner of with the waste. And for me, that was a landmark case because we had to balance between the health of the people and where we are supposed to dump our waste. We had another landmark case whereby the court was very specific that when people are traveling from Nairobi to Western, they need to have places where they can actually go and answer to the calls of nature. And there were directions that indeed we should have toilets. The government should be able to put toilets along the road so that we are able to have those people using buses and matatus to use those particular facilities. And of course, that's an ongoing conversation. I think the government is implementing that particular directive, though slowly, but I'm very sure that that's going to happen. The other issue that the court has dealt with, and this is an issue which is in the Court of Appeal, which I really don't want to discuss about, but we all know about the lead case in Mombasa. And the court, the Environment Land Court, was very firm about it, and it's an issue which is still under conversation as to whether the court was right to say that the people in that particular area should be compensated or not. So those are just some of the few issues that I can say have really had an impact on the society as a whole, insofar as the decisions of the court are concerned.
The interesting bit about the three examples that you've given, Judge, it's where members of a community feel that their rights are not being upheld. And they come to court, and the court is then able to make a determination and take a position on whether their rights are being violated or not. So it's not, people may think when you talk about the Environment and Land Court, it's when you have a dispute with somebody about purchasing a piece of land, about occupation of a piece of land. But then you're also talking about communities. If you feel that A, there's pollution, B, you've been denied access, let's say to public beach, or C, the community is being denied access or the right to enjoy life peacefully, they can also come to court.
Yeah. In fact, when you look at the Constitution, Article 70, Sub-Article 3 is very clear that when it comes to environmental disputes, you don't have to show that you've been affected in any way. You don't have to prove that you've been injured. Anybody can move to court and say that I'm seeing a violation or a threat, and the person will be asking the court to make certain orders. And that article has really given Kenyans a leeway, especially in environmental disputes, to come to court, to the Environment Land Court, and say that I'm seeing certain violation in terms of environmental issues, and therefore I want the court to make a particular pronouncements either against the government or against whoever is violating the environment for the greater good of the country and the globe. Because environmental issues, we always say, do not affect an individual. They affect all of us. Yeah. And therefore, the Constitution has now gone out of its way. Because initially we had the problems of what we call the locus, whereby you'll be asked, if the river is in the river, you are in Western, how does that river concern you? Yes. But nowadays, that is not the issue. We don't ask you, how are you injured? All we say, give us evidence, and we'll give the appropriate orders. So it has really opened up space, and the court keeps on making determinations. And these determinations have also been encouraging people to come and seek those particular orders for the better benefit of the public and the globe.
You know, land issues have always been referred to as very emotive issues in this country.
Yes, they are.
And as the population of this country increases, unfortunately, the land mass doesn't increase with the population. It stays constant. This may not be a matter that directly relates to your court, but it's a land issue. How is it that we still have certain parts of this country where people do not have title deeds?
Yes, we still have certain sections of the country where we've not done titling, and titling is a process. Now, this process is led mostly by the executive, because when you look at the Land Adjudication Act, which is the act that actually provides a framework for titling, you will find that the process has to be commenced by the executive, whereby you start by mapping the area and then bringing in what we call the land committees, the village elders to determine the boundaries, and then the process goes on until the titling is done. So I can attribute to the absence of titling in certain parts of the country to the political. That's a political question, because it has to be started by the ministry. It's actually a policy issue that we now want to do titling in this particular county, and therefore there must be that particular decision at that particular point, and then the process will begin. It's a little bit tedious, because you see, when you're talking about titling, you really have to consider so many things, including the interest, because you determine now the interests of individuals. But that will not be a problem going forward, because after 2010, you realize that now we have what we are calling the community land. So that communities are now being told by the law to come together as a community and register even land as a community and be able to get a title as a community. Because the problem that we've been having in some parts of the country is that certain communities will prefer to have their land remain as community land. They don't want this individualization of titles, especially in the pastoralist communities. They will prefer that the entire division or county should just be considered as a community piece of land, and then you have what we call the groups being registered, maybe in terms of clans and such things. So the challenge, just to answer your question, the challenge mostly was the issue of certain communities preferring to remain with their land as a community and not to individualize those particular titles. But secondly, it is a political question which has to be commenced at a certain level.
Now, you mentioned that there is a conference. There are some discussions that you are planning to have in the not too distant future.
You are very right, and that is one of the main reasons why I really wanted to talk to the Kenyans. The Environment Land Court was operationalized in 2012. The first batch of judges, the 15 judges, were appointed on 1st of October, but they started working formally in early November 2012. So the court is going to commemorate 10 years. Now, this commemoration we have a theme for this particular commemoration. We are calling it ELC at 10, 10 years of protecting land and environment. And we are acknowledging as a court that we've had challenges, serious challenges. We've had gaps. Now, we want Kenyans to come together in this particular commemoration function and discuss on exactly the achievements that the court has had for those 10 years, the challenges that the court has had, the gaps that are existing. Now, this particular conference brings together the two main ministries, that's the Ministry of Lands and Fiscal Planning and the Ministry of Environment and Forestry. We are bringing together all the magistrates who deal with environment land matters, the tribunals. We have so many tribunals under the court. Then we have our stakeholders, whom we call the court users. These court users, we want them to come and tell us what exactly are we doing as a court for purposes of either improving or coming up with the new measures to be able to serve the Kenyans better. Now, it will be a plenary conference. It will not be a hotel conference. It will be a plenary conference because we want to go out there and meet with the people.
Yeah.
And we are going to have it in Kisumu City. So it's going to be a plenary conference whereby we'll have break-up sessions and roundtable sessions with the specific thematic areas, whereby we are inviting even academia and the media and the politicians so that we discuss particular thematic areas for purposes of the people telling us exactly how do we deal with those particular thematic areas. And we already have a few committees who are preparing what I can call the conference, the thematic areas, so that we are very specific on the issues that we want to discuss and the resolutions that we want to come out with. And to add on that, we also want to remind people that this court is not just a land court. You know, we are considered as if we are just a land
just
court.
land.
It's an environmental court, and there is a lot out here that is going on in terms of environmental degradation. So we want to enlighten Kenyans that we need also to deal with environmental issues. Before the conference in the first week of November, we are going to have what we are calling pre-conference activities in all the 36 counties where the court is located, whereby the judges and the magistrates are going to mingle with the people and grow trees, green rivers, green markets, green schools, and also have open days, so that people should be able to understand that indeed this court exists and this court functions in a particular way. So we are going to have those pre-conference activities before the real conference in the first week of November. And a few courts have already started their pre-conference activities because we really want to green this country. It's a green court, and we need to green the country, and we can only do that if we lead from the front. So we are calling upon most of our development partners, because they're the ones who are going to support us in this endeavor, so that we make this conference succeed and have firm resolutions on how we want to assist Kenyans in matters to do with the environment and land.
Right. Even as you look at that conference, I just wanted to look back on the issue of time. And you talked about some of the challenges that you would be discussing during this conference. But is time a challenge in the adjudication of some of these cases? We've seen in the general court system that some of these things actually do take a lot of time.
They do. In fact, that is the main challenge that we have had as a court. However, if you look at our reports now, we are moving from this period of 10 years where matters have been in court for 10 years or even more, up to now we are doing a turnaround of 3 years. So we are looking at having a turnaround of 1 year in the next 3 years. And those are some of the issues that we are discussing as a court. And we've put strategies in place, because even the Chief Justice has told us we need to have strategies in place to have a turnaround of a case to be 1 year. And we are actually working on that. If you look at the record that we now have in the court, we are moving towards the 1 year period. We are still doing a turnaround average of 3 years, but we are geared towards 1 year. And some of the strategies that we've put in place is we want every court file to have a date. You know, we've been having, you go to court and you are told this matter will be mentioned. You don't know when it will be had. So we want to have those particular issues dealt with, so that in the next 3 years, and I'm hoping that it's going to happen because we are determined, we are going to have a turnaround of 1 year in terms of a dispute. It doesn't augur well when you are in court for 10 years or 20 years over land.
Because that is locking down a lot of potential.
A lot of it.
2 weeks ago, we hosted your superior, Justice Isaac Lenaola, who chairs the ICT Committee of the Judiciary. And he was telling us that now with ICT, many courts are getting their work done faster and more efficiently. How have you embraced ICT in the Environment and Land Court?
In the Environment and Land Court, we have embraced virtual hearings, whereby, first of all, we mention all our cases. Like from this studio, I'm going straight to my chambers. I'll not go to the open court. I'll mention all my cases virtually, and you see now you are able to deal with people from all over, wherever they are. You can actually mention your case from this studio. We deal with applications. Advocates argue their applications virtually, and of course litigants. When it comes to hearings whereby you're supposed to come and produce documents, we have a mixed system whereby you can either opt to come to court and produce your documents, or you can actually agree that you are going to do your hearing from wherever you are. And it has been a great achievement. So we are doing very well in terms of virtual hearings. The only thing that we now need to impress, and this is some of the discussions we are having, is to digitize the court completely. It's not completely digitized. We are still doing longhand proceedings. Have to sit and write whatever you are saying. So we need to improve on that. If we do away with longhand writing, you can be very sure that the period that we take to handle a file will reduce by more than 75%. Yeah, because you can imagine I'm writing from morning to evening.
Yes.
So there is no way I can move faster as expected. So we are actually engaging our development partners to be able to assist the court in digitizing the court completely, so that we stop this tradition of long writing. But we are doing very well when it comes to ICT as a court.
Okay. That case by lawyer Adrian Kamodo on the one that now got the judgment of the court, let the Ministry of Transport make modalities of ensuring their toilets and facilities on the highway landmark. Issues of environment now that we are seeing actually go beyond just land and pollution of rivers. There's such access to facilities. Then it brings the issue of sanitation, especially in the low-income areas, like in an urban area such as Nairobi. Very many people who don't have access to sanitation, yet it's a constitutional right.
It is.
Are there such cases that are, on your list of cases before court?
Yeah, they are there. We have those cases, and they are not few. They are increasing in number. They are not very many, but they are increasing in number, because we know under Article 43, every person has the right to a clean and healthy environment, including the right to sanitation, clean water, and accessible housing. So those cases are actually coming up, and we have a few decisions. You remember the Mitubel decision, where the Supreme Court said that the people in Mitubel, which is an informal settlement, should be able to be settled, so that they have what I can call decent living. So those are issues that the court is actually encountering, and the numbers are going up, and it's a right in the Constitution. So once we look at the facts, then we will be able to enforce that right, because they are entitled to it as human beings. Yeah, we all need to live a dignified life, notwithstanding our backgrounds.
Indeed. What's your caseload at present?
Our caseload has come down from 27,000 cases when we started the court in 2012. Right now we are at 11,000 cases. The entire environment land court, we are at 11,000. And because of our high clearance rate, because we are now doing around 159% as clearance rate. Clearance rate is where the number of cases you are dealing with should be higher than the number of cases filed. So we are clearing our cases at a faster rate than the number of cases being filed. So we are at around 159. So we are hoping that in the next 5 or so years, that caseload will have gone down. But we are now at 11,000, with around 4,000 cases which are more than 3 years old. And one of the requirements by the Office of the Chief Justice is to make sure that we deal with those matters which are 3 years and more expeditiously, so that we remove them from the system. So that's our caseload, and we are very particular with statistics nowadays. We are very good at it. because we realize that if we don't do that, then we will not be able to know exactly what we are doing. So we have those statistics. We are at 11,000 countrywide.
You recently got several judges who were
Yes,
sworn
we
in
did.
and
We
joined
did,
the
and
court.
that's why we really have high expectations that those numbers should go down drastically. Because we started off with 15 judges, then in 2016 we were given and we employed 19 judges, and in last year we had 18 more judges. So we are now at 51 judges. So that is a good number,
Yeah.
and that's why we've been saying that going forward we should be able to really reduce the backlog that has been there for a while.
Justice Angote, thank you very much for joining us today. Thank you for coming to shed light on what the Environment and Land Court has been doing, and congratulations on 10 years and all the work that you've done, clearing from 27,000 cases to 11,000, and working faster than the way you are is a good thing.
Thank you very much for inviting me, and we are inviting the media to celebrate with us the 10 years of the existence of the court. And going forward after that particular conference, you can be very sure that we are really going to be on top of things.
Asante sana.
Asante sana, nimeshukuru. Thank you for this opportunity.
Kisumu tunakuja. Good morning.